What's up, viewers, subscribers, and agents alike? It's your boy, Luciferian Prince, coming at y'all once again with another upload in regards to my series and furthering on the cause for the mundane. Now, I know that we are not 24 hours within this bogus year. Just to keep you updated, it hasn't even been 24 hours yet. And unfortunately, spirits of chaos is still working out there in the world. I want to say first off, rest in peace to the victims of the atrocity that took place in New Orleans. The individual who ran his SUV through a crowd of, people who want to just gather and have a good time for the most part on New Year's, and senselessly took the lives of them. Somebody didn't want to be here any longer, unfortunately. So rest in peace to all the parents in regards to that situation, and families and loved ones too. As I said, people, as time goes on, we're not even 24 hours into this, and the madness keeps coming. Not to mention how totally and blatantly absurd it was for a record-breaking number of people to attend the so-called ball drop in Times Square, New York. And the crazy thing was, they didn't even drop a real ball, people. Record-breaking numbers for something that particularly didn't happen. So, people, although it be Gregorian-style New Year's, I'm taking this as just nothing more than another day. Now, if you're watching this video around children, please remove them from your immediate vicinity, as my videos are not for children. If you're looking at this video in regards to anything I have to say regarding anything that constitutes legal advice, it sure does not. The sole purpose of this information is for educational and informational purposes only. Okay, so the first video I'm going to do in regards to this upload is to talk about arbitration. I know a lot of people, they come up to me in the comment section or emailing me, asking me questions about repossessions or anything as far as foreclosure is concerned, or finance contracts within regards to any commercial transaction that you've undertaken. It's all gravy, people. But again, this does not constitute legal advice. Okay? So if you're in need of services of an attorney, irrespective of who you hire, they're going to lie to you anyway and tell you little to nothing they can actually do about it. Because if you look on corpus juris secundum, attorney and client, you'll see exactly what I'm talking about. There's nothing left to say in that respect. So if you want a lawyer, go get you one, pay your fiat, and retain their services. Other than that, this is just for general and informational purposes only. My wife did not close the bathroom when I was recording, pardon the toilet noise in the back. Some odd reason she is a recording nuisance for some odd reason. And I'm not redoing this. This is the reason why I mentioned that. Thank you, love. I bet. So with all due respect, let's get to it. Now, a lot of people talk about this arbitration clause, or they very seldom go over it, right? But let me tell you what the sole purpose of this is for. In any contract you sign, whether it's mortgage, whether it's loan, whether it's lease, there is a process called arbitration, which in and of itself is sort of like, it's like a miniature court, but it's not really functioning with all the capacities of a court. It's just strictly limited itself to just a contract and a legal basis of that contract. Now, there is an association that I'm going to put out in the beginning of this video, lest people forget it. If you have one of these functional tools that we call, i.e. an ink pen, please grab one for your own edification and purposes after you watch this video. Now, we have what's called arbitration. But a little known organization that people don't know about is also known as the Arbitration Association of America. Now, what is this? This association helps you litigate whatever claims may arise from rise of a conflict of interest within regards to a finance contract, mortgage, loan notice, whatever. It covers it all. Now, if you want more information on this for your own research, you can look up American Arbitration Association of America's website. You can look it up. They have a PDF that you can download for yourself for you to read to understand how you're going to go about your arbitration proceedings. Since I don't like for my videos to tarry on and I don't like to really be lengthy in them, it's a PDF for your own study and your own edification and research on this subject. Now, why is that important? Because, again, people, it's 2025. Time is getting short, it's of the essence. And a lot of people want somebody to hold their hand in these processes. And I'm telling y'all, it's not going to work that way. Okay? So when I tell people about researching and reading stuff, it's because it's for you to deal with it on your own. Yes, people can assist you, but you have to have this knowledge firsthand so you can make sure that you can assess the situation. So if you have a problem, if you have a question or concern, you don't have to sit here and file an email and wait for somebody to respond 2, 3, 4, 5 days down the line. You'll have that information at your ready, at your discretion, whenever you have a question. Refer to the contents and the actual section of the arbitration manual. Now, are there fees with filing arbitration claim? Yes, but you could also do like you do with any other legal proceeding. You can file in form of paupers, okay? Which means without prepayment of fees. In other words, it's very stylized Latin for as a poor person, but in reality, it's just stylized Latin, people. You don't have to feel offended because you're not filing with prepaid filing fees. It's okay, people. We understand. It's a commercial world. It's all about your perception and how you feel. Now, what this process does, even if you are at foreclosure and even if you are at repossession, it doesn't matter. Because even on the CFPB website, you can actually submit claims of foreclosure, and you can submit claims of repossession, and you can submit all sorts of claims that don't just limit you to just the rudimentary screening of your claims, like say for instance, Experian, Equifax, and TransUnion. All they do is just go over whether or not it was addressed. Nonetheless, as far as the CFPB is concerned, this is the primary bureau of, say, finances and consumer protection. This is the bureau that's specifically designed to this. If your claim or your complaint does not fit for the office of CFPB, they will fundamentally forward it to the office in which it is concerned, free of charge, no charge to you. Just be lucid and very open in your complaints and your claims. Now, what I will tell people in this video is how do you actually win a viable arbitration claim? Again, most of the time when people come into this knowledge, they're often rejected, they don't get no response, or the people basically say, in light of better words, since it's a video that's not for children but for adults, they politely just tell you to fuck off with no response. Now, does this mean that anything that you're saying in your claim is wrong? Does this mean that anything that you're saying in regards to your stance as far as filing this complaint is wrong? No, it's just this how you build your claim in arbitration. The more they put off the paperwork, the better off you are. The more they don't respond to the paperwork, the better off you are. The reason why I say this is because your claim does not have to change. If you sent the correspondence to them a year to 2 years ago and they didn't respond, then get on your arbitration game and file that paperwork with the American Arbitration Association of America. Get in touch with them people, because again, there is not much you have to do to substantiate a claim in arbitration when you already in advance, gave them what's called an opportunity to cure. So when you send off your documentations like, your remittance coupons, or you send them off your acceptance for values, or your creditor disclosure statements, or you send them off all your affidavits, all of these things are used as elements to hold your claim up. The reason why most of these corporations get away with this is because, number one, most consumers don't use the arbitration process, or number two, most people either default and totally go to the next step with the alleged creditor actually saying, hey, he or she owes us. Well, that's BS. If you file these proper paperwork and documentations with these entities prior to it even getting to a rise of measure, what's going to happen to them in arbitration court or arbitration proceedings, I should say, not court proceedings, is that they fail to state a claim upon which relief can be granted. What does that mean in legalese? In simplest terms, it means that they have no grounds to go forward to defend a claim in which they basically defaulted off of. If you said, hey, particularly to ABC credit card company, I would like for you to fill out this creditor disclosure statement. Please send it returned to me signed within the time period allotted. If they don't respond, you go to arbitration. If you have had your vehicle repossessed, you go to arbitration. You state the claim, you state the account, you state everything that you need to state as far as your claim is concerned. Please make sure it's a viable claim. I know it's very disheartening when you deal with these entities for all intents and purposes, because I don't care what nobody says. Whenever you get a vehicle repossessed, you must read the financing contract. The financing contract, in an event of default, only says that interest rates will be charged to your vehicle and the possession thereof for failure to make payments. Now, a lot of people say, well, you signed a contract that gave the towing company the right to come repossess your vehicle. No, it doesn't. Because in reality, that car, that property is still your property, which is one of the reasons why it's a civil thing, why they always have to catch you slipping. You know what I'm saying? They always got to catch you outside the vehicle, or they always got to catch you where you ain't in it. Or if you have a garage, they can't come in and come take it. If it was their vehicle and they actually did have a right to claim by it, by law, they would bring the sheriff to come to your house and come acquire their property. But they can never acquire their property because if you read the financing contract, it says security interest is yourself, you and the actual dealer, not the lender. The lender never loaned anything. The lender is just there as a backup party to say, I have been assigned the title for the vehicle, and basically by me assigning the vehicle, I just go and barter out with a towing company in the area where the vehicle is located, and I'll pay them a cut off of repossessing something that really don't belong to us. But in law, we can say it does because we have the title. That's how they fuck over a lot of people. But it never says in the financing contract that they are actually allowed to actually acquire the property. It just says that interest will accrue. However, let me tell you something about this. This is a breach of contract because even the Supreme Court ruled that financing companies can only gain interest off of things that are commodities, like coffee and soil and sugar, and stuff like that. That means that that person, that entity had to take their exact money and then gain interest off of what they had spent, off of what accrued from a commodity, not an asset. Okay? Interest is only raised off of commodities, not assets. So with that being said, those are all the hidden traps within a financing contract. Now, once you go forward with this arbitration proceeding, they're always going to say you failed to pay. But what you're stating in your claim is, I, prior to the repossession of said property, asked you to validate your stance in regards to you being owed. You see what I'm saying? Anything from me, the natural person. Now, if I'm asking you to validate this, I'm not denying, or am I not either saying that you are or you aren't the creditor to this action. But I need all this information because, again, if you look at the lender on any financing contract is considered the assignee. You see what I'm saying? They're the assignee. They're to whom it has been assigned to, or the people who hold the deeds to mortgages. They are the assignee. You see what I'm saying? So the realtor in the mortgage company is the person who actually was like, look, I'm going to use y'all face card because y'all are certified to be looked at as a lender, although the person who signed this documentation ain't that smart. So we going to go ahead and trick them. So the realtor is the one who actually commits the fraud because they initiate the promissory note into the assignment with the third party entity that after you sign the documentation, they flip it 1 time, 2 times, 3 times. because in reality, they never owned the actual security interest. It was only by assignment. To go on the record publicly as a ledger to say, hey, we are a financing company, but not proving to the actual signer that they either loaned something of commensurate or actual value. They just said we loaned you something. Saying something and proving it are not two things. You see what I'm saying? So whenever you have these conflicts of interest, it is your responsibility, especially if you're taking out a loan to a bank, is to file an actual affidavit with the bank saying that these corporations that are considered lenders, they go by what is called GAAP. You know what I'm saying? General Actual Accounting Procedures. In other words, that these individuals cannot deviate from that. Do your research, look up GAAP, GAAP, and look how it applies to all financing contracts. Every corporation that loans a contract that has to deal with any type of loan or lease or anything on an IOU has to abide by what's called GAAP. So when you got all your documentation in a row, normally it takes about 2-3 letters. Maybe you wrote some cover letters. You might write a notice, initial one. You might write a notice of default saying that they failed to not respond. You send the attachment. This is what you send with your arbitration complaint. And once you send this in with your arbitration complaint, your so-called debt collectors do not respond to you anymore. If they have anything to say, they are to respond to the American Arbitration Association of America. It is no longer nothing you need to deal with. You are just strictly going by what is in the terms and conditions of your financing contract according to arbitration, and you want to seek recoupment in these arbitration proceedings. Simple as that. So if your vehicle is about $60,000, $70,000 and these individuals repoed it or still seeking some type of payment from it, then you need to seek arbitration ASAP to get that back. Because when you signed that financing contract, when you signed that piece of paper, you already paid for it. It's just that the simple fact of the matter is the one trap that got you is a promissory note. But the promissory note is null and void upon its faces because these individuals are not supposed to exact interest on anything that is not a commodity. That's a proven fact. Supreme Court has ruled on. Proven fact, not known to be overturned. So with that being said, your best bet, if you are dealing with foreclosure, any type of loan, whether it's student loan or anything that's dealing with an open-ended contract that tries to make you liable for the collection thereof, seek arbitration, and that's in less than 18 minutes. Just that simple. You know what I'm saying? If you are dealing with the bank and the bank turns around and say they gave you a loan, well, according to the arbitration contract, the bank has to provide itself with the necessity of saying, number one, that they never took the promissory note as a loan. Number two, in order for a loan to be given, it must be backed by a document that the bank actually took out its money to finance a loan. No entity ever does that during the financing contract because what binds a financing contract is nothing more than a signature of what they call in UCC 3419 is an accommodation party. So anybody that signs a contract is just a mere accommodation party. That's it. And I told you in less than 19 minutes. So seek arbitration and go out there, man, get what belongs to you. And stop letting these corporations and so forth bully y'all. But if you don't want to take my word for it, you can cut this video off and act like I didn't say a damn thing. Act like I didn't say a rabbit ass thing. Because it's just the way these corporations are. And I think the longer we stick here and stay on these channels and these airwaves and this knowledge expounds, because it's never ending, you'll start to see that you really are owed a lot more than what's been taken from you. It's just that this corporation we know as the United States is more apt to trying to keep everything in order for it to recoup the bankruptcy and Chapter 11 reorganization expenses that it came up with at its own behest. The American people should not have to suffer. So in other words, irrespective of race, color, nationality, creed, or origin, don't matter. You should not take up another person's debt. The only thing you're supposed to do as a sovereign individual is pay your just debts. Not some fraudulently crafted, constructed debt that allows me to say that I basically paid for something that I had to pay again because somebody has usurped my trust as a beneficiary under misleading representations, but to pay the just debts that I incur myself. But as a creditor, I can't make that. I can only absolve myself of it. I can only contest debts. I cannot make them. Just remember that, future reference. If you're watching this channel into 2025, stay tuned. We will come with more surprises in the next coming weeks. Universe provided, all is well, and we still rocking and rolling. But this is understanding your course of arbitration and how you can actually get your recoupment back. Further information, further inquiries, you have to email me for consultation and so forth and so on. As of the recording of this video, January 1st of 2025, Gregorian, yes, for consultations, fees do apply, people. All those who are new to my channel, so forth and so on, new year, you're new to my channel, thanks for my subscribers. But remember, people, in regards to this process, freedom ain't free. You got to work for it. And just because somebody will make it seem as if it's very easy and just openly ended, no. You have to understand that a lot of these methods that we're teaching about people online is for people to understand they are not going to take kindly to you because you are affecting how their commerce runs. So if they don't stand anything to gain from you, they're not going to entertain you. See what I'm saying? If you become a resistor or a debt resistor, such as myself, then you're not going to be looked at as nicely or very kindly, or they're not going to be rushed to try to take you to court. Because they know if they do try to take you into a legal proceeding, they know that they're not going to win because you have totally pulled the plug on their swamp of fraud. And I'm going to be the one to say it. Millions of Americans upon Americans have been introduced to this. It's 2025, people. Most of this stuff has been out since the early 2000s. And it's so crazy that it's just that it's still a handful of people who can actually grasp this concept. But unfortunately, as it says, the unseen hand don't stop and making sure it thwarts people off the path of correct and true total freedom, which is financial sovereignty. I think people can all agree that the number one thing that most, if not all, people aspire for, aside from other things for moralistic purposes, is financial sovereignty. And it's just completely to be left alone. It's not a revolutionary movement. It's not, let's all fight the power. And no, I'm not naive like that. But I will say, it comes a time when you have to just stop being that soda can that's proverbially kicked around and get put back on the shelf where you deserve, and you can retain your value. Simple as that. Small analogy, but you get the picture. So, like I said, email me, hit me up, let me know what it is you want to proceed with this next year. For people who are tripping about the tax forms, please relax. It is A-OK. The IRS is having a hell of a problem. It's only January 1st. It's good to have your paperwork in there early, but I'm letting you know that right now. It's great to be early, but I'm telling you, when it comes to these people, they take weeks, if not months, to process forms. Just stay calm, work persistently at what you're doing, and make sure you got all your motherfucking I's dotted, your T's crossed, so you don't have to have a delay in your paperwork being reprocessed. Because rushing can sometimes make you do some things wrong. But that's just the word of advice. So, with that being said, take it easy. The people backlog. Remember, there's hundreds upon millions of people in the United States. You're not the only one. Just make sure your letters are cooperatively dated. That's it. Sit back, enjoy the ride, work on your next project. Other than that, y'all support the channel. Y'all support the content. Stay tuned. Still trying to tweak out this podcast equipment. See what's up with the mic. The tone is just a little low, but small thing to a giant. We're working on that. We getting there. To all y'all that subscribe, keep subscribing. Hit that notification button so you get the vibration notification every time I drop heat. You'll get the notice, and you won't be left outside the loop for a lot more things going on into the new year. So stay tuned. Peace, light, love. Gregorian into another year, 2025. And agents, man, fuck you. It is what it is. It is what it is. This is the year of enlightenment. It's the time. It's your turn. If it ain't your turn, act like these videos don't exist from this day forward. Because, hey, The choice is yours and yours alone. Peace, light, love. Y'all stay tuned. Take care. See y'all soon.